Thank you. Can I refer members now to item number 4 on your agenda, which is your draft minutes? Can I refer a member to the draft minutes of proceedings at pages 27 to 42 of your meeting pack? Are members content that the draft minutes of the meeting on Thursday, the 9th of July 2026 are true reflection of proceedings? Agreed. Thank you, members. Move on now to item number 5, matters arising, and there is no matters arising, so we're going to move on now to item number 6, which is Regulation EU 2026-1703 as regards the prohibition on the export of mixed municipal waste destined for recovery. Can I inform members that this item will be recorded by Hansard? And can I refer members to the relevant papers at pages 5 to 26 of your meeting pack and page 3 of your tabled papers? An assessment of impact from the Department of Agriculture, Environment and Rural Affairs can be found at pages 19 to 21 of your meeting pack, and correspondence from the Cabinet Office can be found at pages 3 of your tabled papers. It states that due to the targeted and technical nature of this amendment, the British Government has not prepared an explanatory memorandum and has instead set out its assessment of the EU Act within the letter. The British Government states that this amendment provides exporters here with greater flexibility on where they can send relevant waste. It also states that the practical impact of that flexibility is likely to be limited because Switzerland is not a significant destination for export of relevant waste from here. Can I remind members that the committee will need to take a decision whether to hold an inquiry, and will do so following our evidence session. So can I very much welcome Shane Doris, Director of Environmental Resources Policy Division, the Department of Agriculture, Environment and Rural Affairs, and can I welcome Keith Carlisle, Policy Lead with the Department of Agriculture, Environment and Rural Affairs. So thank you, gentlemen, for coming along this morning, and just whenever you're ready, I would ask you to brief the committee. Thank you.
Thank you, Chair. Appreciate the introductions. I'm grateful to the committee for their time allowing us to present our initial assessment. As you noted, we are here today to talk about Regulation EU 2026/1703, amending Regulation EU 2024/1157 as regards the prohibition on the export of mixed municipal waste destined for recovery. That initial regulation, EU 2024/1157, entered into force in May 2024, and following the democratic scrutiny period under Schedule 6B of the Northern Ireland Act 1998, including engagement with this committee at the time, the regulation applies fully in Northern Ireland. Specifically, Regulation 2026/1703 amends point F of Article 44.2 of Regulation EU 2024/1157. The amendment introduces an exception for Switzerland to the existing EU ban on exporting mixed municipal waste for recovery to third countries. Article 44 sets out the general regime for the exports of waste. From May 2026, point F prohibited the export from the EU of mixed municipal waste destined for recovery in third countries. The amendment, so Regulation EU 2026/1703, introduces an exception for Switzerland. Now, the article would now read, the export of waste referred to in Article 4.3 shall be prohibited except to Switzerland. This exception will apply from the date the amendment will come into force. Excuse me. Without this amendment, transfers of mixed municipal waste from EU border areas to nearby treatment facilities in Switzerland would no longer be authorised. This would end a long-established practice, and the practice involves facilities in Switzerland where high standards of waste management are maintained. DAERA officials consider that Regulation EU 2026/1703 and the subsequent amendment to point F of Article 44.2 of Regulation EU 2024/1157 does not introduce substantive policy change specific to Northern Ireland and is primarily a narrow and technical amendment. The impact of applying the regulation, as the amendment addresses an issue relating to a long-standing practice between Switzerland and border EU member states, It does not appear likely that applying Regulation EU 2026-1703 would have a significant impact specific to the everyday lives of community in Northern Ireland in a way that is likely to persist. An impact of not applying the regulation, for the same reasons as above, it does not appear likely that non-application of the regulation EU 2026-1703 would have a significant impact specific to the everyday lives of communities in Northern Ireland in a way that is liable to persist. The current position within Northern Ireland currently does not export mixed municipal waste to any non-EU countries. However, if the regulation wasn't applied, such waste shipments could not be sent to Switzerland in the future if that was something that Northern Ireland wanted to do. So the origin of the amendment, the motivation for the change appears to have been a question raised by an MEP who highlighted decades-long cooperation from EU member states with Swiss waste incineration plants. Highlighted the economic value of the short transport routes by rail, the contribution to Swiss energy generation and district heating supply, and the avoidance of heavy goods vehicle traffic travelling to Germany. There has been no explanatory memorandum provided or prepared by the UK government, nor has the European Commission prepared an impact statement. Presumably this reflects the very narrow and technical nature of the amendment. There has been no engagement by the Department on this amendment. The Department was only made aware of the amendment when it was published in the official journal of the European Union on the 10th of July 2026. This is considered to reflect the narrow and technical nature of the amendment. Thank you, Committee, for your time. I'm now happy to take any questions that you might have.
Thank you, Keith. Any members have any questions? No, there's no questions this morning. So can I thank both Keith and Shane for coming along, for presenting and providing that paper. Thank you, much appreciated.
Thank you very much.
So members, under paragraph 8.1 of Schedule 6B to the 1998 Act, the committee must decide whether or not to hold inquiry on the published replacement EU Act that has been notified. Should the committee fail to decide, the failure will be treated as a decision not to hold an inquiry. So having regard to the legal advice on whether it appears likely that the replacement EU Act significantly differs in whole or in part from the content or scope of the EU instruments which it amends and replaces, and the departmental assessment on whether it appears likely that the replacement act would have a significant impact specific to everyday life of communities here in a way that is liable to persist, can I ask members, do they wish to hold an inquiry into Regulation EU 2026-1703? No? Everybody in agreement? No? Yeah, nothing contrary. So can I advise members that the committee's decision will be published on its website, and I will now ask members, just move on here. Right, we're just going to move on now swiftly to item number 7, members, which is committee travel. I'm going to invite Chris to provide an update on the planning for the committee's proposed visit to Brussels in the autumn. So, Chris, if you want to give a wee update.
Thank you, Chair. Yes, so members, at our last meeting I had updated on our preparatory work for this visit, and I noted that we'd sought a steer from the Office of the NI Executive in Brussels on what dates in October might suit practically, both in terms of utilising their offices and so on, and also when might be suitable for meeting some of our intended stakeholders, given that, especially for the permanent representation of Ireland during Ireland's Council presidency, time and availability might be at a bit of a premium. October is quite a busy month both for stakeholders and for ONIB themselves in terms of other engagements. They had identified a date range in October that would have worked for all of those moving parts, which was the 6th to the 8th of October. That would suit practically on their side. However, members' availability on those specific dates was quite limited. So more than half of the committee had already indicated that they weren't available on those dates. The other thing I should note is that we understand now there's growing expectation that the UK-EU summit, which had previously been scheduled for this month, is now likely to be in late October or early November. That's still very much to be confirmed, and there hasn't been any formal indications, but that seems to be the sort of popular view of when that might be. In similar circumstances before, the committee had a preference to wait until after the summit in terms of ensuring that the discussions we have are sort of as useful as they can be for members. So it might be the case, given the sort of difficulties on dates and availability, and noting that there's some sort of there's a popular view that summit will be at the tail end of October or early November, that we might wish to simply just hold fire and see when that is and schedule after that has taken place. But I'd welcome your views, Chair, and those of committee members.
Yeah. Steve, just wants in. Yes, Steve.
Yeah, thanks very much indeed. Sort of yesterday, I was at the Farnborough International Air Show and talking to quite a few sort of trade people. The indications are that I don't think there's going to be any early move towards a UK-EU sort of trade discussion on agreement, and I think November would be very optimistic from what I'm hearing. So I suspect it would probably, if we wait too much longer, we're going to be heavily into election season, and I'm not going to be traveling anytime after October for anything when we've got a big election coming in next year. So I would advise we stick to the dates in October and go for it in October.
Any other thoughts from members?
I'm happy to go with Steve's proposal there. If we stick for October, what were the couple of dates? Remind me again, Chris, that we had.
So it would be the 6th until the 8th of October. I should note, Chair.
What was the other dates that you give in that email, if I remember right? Because I can't remember.
There were two other date ranges in October that ONIEB have ruled out from their practical perspective. We could certainly revisit our options for a visit, notwithstanding that, but it means that we have that sort of space isn't available to us. They had indicated that the 6th to the 8th of October would be workable, both in terms of that practical setup and for some of the engagements that we had intended to have. But in terms of members' availability, once we had written around on that, I think it was a maximum of 3 committee members would be available on those dates.
Is there something that just spitballing here? But is there something to be said for looking at if Brussels is proving too awkward at that point, looking at London, given the changes in London and the fact that the engagement we done, well, it's not lost, the engagement we done at on the last visit, but obviously there's a change in personnel there, and who knows in terms of what that means for the approach. So if the Brussels trip is not working out, we usually do them sort of in order, if you will, but whether it would be worth looking at doing some of those engagements in London, given that there's been significant changes there. No? Okay.
No, certainly from my perspective, it will be led by the committee on that.
Because I can't remember if I came back to you to say if those dates did or didn't suit. I think I said it didn't, because I did have an option, and there was one meeting that I had on a Wednesday. But if it was to suit the committee, look, I could make myself available for the 6th to the 8th meeting, or in, I think it was Brussels, if that's tips the balance in terms of majority.
Yeah.
Okay.
Well, if members are content to proceed, I would have thought that I would have preferred, obviously, to go to Brussels once the summit had taken place. So we generally know the lie of the land, but I understand, obviously, Steve as well. It could push way back into November, December time, and we will be then flat out as well. So I think if most members here are content that we proceed then with the 6th to the 8th, given that the Brussels office are able to content to accommodate us at that time as well. And hopefully if any other members then can make themselves available.
Yeah, one other point, I think David does raise a valid point, and I would be happy to support if there's a way in which we can incorporate a form of London visit to incorporate the new Secretary of State and Under Secretary of State. It probably would be helpful at some stage. I'm not saying when that will be. I think our priority should be just to scope the lay of the land in relation to where these negotiations are gone.
Okay, if committee's content, then we would take that as an agreed action to explore options for a Westminster visit after the summer recess as well, and the staff can come back on that.
Yeah.
Yeah.
Okay, is that okay? Yeah. Okay, members, I'm going to move now on to item number 8, committee work planning. So can I refer members to your work planning document, pages 46 to 56 of your meeting pack. And just Chris is going to update members on 2 specific proposals.
That's great. Thank you, Chair. Yes, so the first of these updates, just to draw members' attention to, relates to a proposal for a regulation regarding end-of-life vehicles, which is at number 6 on your work planning table. That's at page 50 in the meeting packs. You'll see from the table that the committee had previously requested a revised assessment of impact on the provisionally agreed text of this proposal, or confirmation from the department that those previous assessments of impact were still unchanged. The committee was then informed that discussions were still ongoing between departments and the UK government to clarify what elements of that proposal would or would not apply under Article 13.3 of the Windsor Framework. And the committee had agreed just to reissue that request once there was further clarity. The update here is just to note that since then the proposal has been adopted by both the Parliament and the Council, so we're awaiting publication in the official journal in the coming weeks on that one. We've therefore sought an update from the UK Government, and we understand that an EM will be provided along with the notification on that published Act, and that EM will clarify the position around applicability. So with that in mind, it's likely just that the way that the request will issue would be in line with our normal procedures on a published Act, and once that clarity is there, we'll get it in following the notification. The second update, just to note, relates to a proposed directive which was previously notified to the committee, and that had been documented on previous versions of the work planning table. It was COM 2025-1021, which is a proposed directive on food and feed safety. Members might recall that in April the committee took a decision to monitor a related proposal that sort of came as a package with that. That was the proposed regulation in the same package. You'll see that one there at item 18 on the table. Again, the committee had previously been informed that on this proposed directive, discussions were still ongoing around applicability, and so we hadn't scheduled any evidence sessions until we had that clarification. Again, we've now received confirmation from the UK Government that it is not, in fact, directly applicable in Northern Ireland under the Windsor Framework, and therefore the notification has been withdrawn. So the committee staff have informed all of the relevant contacts on that, departments, legal services and RAIS, just to let them know that that notification has been withdrawn and it's been taken out of the table accordingly. So they're just the 2 sort of updates of substance for members to know.
Okay, thank you, Chris. Are members content to note? Yep, thank you. I'll move on now swiftly to item number 9, which is then correspondence. Can I refer members that there are 11 items of correspondence at pages 57 to 102 of your meeting pack. I wish to draw your attention to item 9.6, and it's at page 80, which is a copy of correspondence from the House of Lords NI Scrutiny Committee to the British Government regarding an EU Act known as the EU Breakfast Directive. It was published and notified to the committee back in May 2024, and its implementation is therefore now a matter for the relevant statutory committees. The Committee for Health has previously considered the statutory rule which transposes it into domestic law, including by hearing evidence from the Food Standard Agency. However, members will note that the correspondence has not yet been shared with it by the Lords Committee. Are members content to forward this correspondence to the Committee for Health and to suggest that the Lords Committee copies it into any further correspondence on this matter? Yeah, content, thank you. And then, do members have any other comments on the remaining items of correspondence, or are you content to note? Steve?
Yeah, just looking the correspondence going back about the EU's Industrial Accelerator Act and issues to do with that. I've got some issues to bring up in AOB, but I think it's important looking at the business pieces that this is being to raise its profile, so we need to be aware of it.
Okay, thank you, Chris. Or Steve? So as chairperson's business, I don't have any other business, so I'm going to move on to any other business, Steve. So if you want to raise your issue.
Chair, thanks very much indeed. There's about 4 bits I just wanted to raise and just to put on the profile, and I know we have a view of not being particularly curious about a couple of things, but there's some really important things going on in the EU at the moment we need to be aware of. The first one is about the Digital Markets Act, which is this tariff business that's all going between the European Commission and the Americans. particularly over, I think it's one of the major companies that just fined 460 million euros. The United States are planning to put on very significant counter tariffs onto it. Now, there are implications very much for Northern Ireland, for the fintech sector, so that's something we need to keep aware of over the summer, I would suggest. You will all be aware of the fact that our new government has decided to remove the 5% VAT, or the VAT on energy, but that can't be applied in Northern Ireland. I've raised this issue with officials, but the reality is under the EU regs on VAT, and I think it's on Annex 3 of the VAT directive, there is actually, we could be making quite a strong case that we could be going for special rates and going for zero rates on this, because it's the same as the rest of our nation. Just seems strange that nobody's raising any issues about this, but it should be raised. I think there are flexibilities within the system that we're not taking. And I think that was important, that should be recognised by this committee, that, you know, just because we're incurious, the Northern Ireland Civil Service shouldn't be incurious, and we should be looking at the rules and regulations for the best benefit for Northern Ireland. The third one is on steel trade measures and steel tariffs. The good news is that the minister responsible for this in Westminster, even though he's no longer responsible for that, he's our new Secretary of State for Northern Ireland. So Chris Bryant should be fully on top of this. But there are issues with Northern Ireland companies are getting really concerned about access to specialist steels and steels coming forward. And I know with some people, I mean, in Jonathan's constituency, and particularly out in Mid-Ulster, there are many companies are now getting really concerned about the costs and access to special tariffs and steels. And a piece of good news, I was actually at a meeting last week. I should have made a declaration earlier on this committee call, but I couldn't, because of course I can get the audio to work. That I actually had a meeting with the UK government, and actually HMRC were actually present. So good news on the alliance tax is that now all goods coming into all parcels, except for a small volume which hasn't been defined, are now going directly into GB before they come to Northern Ireland. So therefore aren't going to be hammered with the duty per article. But there has been no answer yet on the administrative charge. So I think that is something we need to keep a very careful eye on it. That's my 1, 2, 3, 4 items of any other business, but just wanted to have that in record so people are aware of it. Okay, thanks, Chair.
Thank you, Steve. That's very informative, I think, for members, so thank you for that. Jonathan?
Sure, just to follow up on one of Steve's points, and I'm not sure if there is anything that we can do given our remit, but the issue around VAT is an interesting one in particular. I have heard that it's being disputed by the Northern Ireland Executive that it's an over-interpretation of the Windsor framework regarding not applying the VAT removal to energy bills in Northern Ireland. I don't know if it's appropriate or if there's a means by which we can get clarity on that, given our scope on the Windsor framework. It may be useful just to find out what is the actual lie of the land on that particular issue.
Yeah. I very much, obviously, we're all kind of a bit in the dark. I do recognise it's probably maybe overstepping our mark. I know if members are on the Economy Committee, because it obviously will be the Minister for Economy that will be looking into this. So it might be something that members could maybe raise in their role if there's members here. I think some of you members on the Economy Committee.
Yeah, no, I'm on it, Chair, but it's just I'm conscious that committee's not meeting over the summer, and this issue is very much a live issue. I don't know, is it an ability for us just to seek clarity in relation to VAT in relation, or VAT on energy bills in relation to its applicability with the Windsor framework?
I know it's not our remit, but look,
for the clerk, if you're looking at it, sorry, Chair, if you're just for the clerk, if they were looking at it, it's very clearly it's let out in Annex 3 of the EU VAT directive, and it's under special measures. So it's not a difficult thing to read. It's quite clear, and lots of EU countries use it. Just seems strange that we haven't.
Is it something whereby that information, Steve, that you have divulged is something that we as a committee, it has been highlighted here today, and that we can just highlight it to the Department of Economy, that we've had a discussion on it at committee this morning, 3 members, and we just want, we would like to highlight 3 members that particular directives that Steve has highlighted.
Yeah, we
for
can
review.
We can certainly take
for information
that
purposes.
I'm conscious just of the points members raised, that while ordinarily this would probably sit within the remit of the Committee for the Economy and noting the timings, perhaps we could copy them into that correspondence and note that it may be something that they want
Yeah.
to take forward following that. Would members be content?
Yes? Yeah. Okay. Any other members have anything to raise? No? Okay, members. So that's us members. So thank you. So obviously, date and time of next meeting. There has been no notifications published. So therefore, our next meeting will be scheduled for the 6th of August at 10 a.m. in room 30 in Parliament Buildings. And that's the meeting now adjourned. Thank you, members.